Surely we have questions for you at the end of the program. Taking us further into today's program is an IP professional who in the course of his job has understudied IP systems of developed countries of the world. He will share with us from his wealth on IP and what IP is and what in particular the rules and benefits of trademark are. Make welcome Principal Assistant Registrar, Head of Deposition Unit, and Head of Certificate Unit of the Trademark Registry, Mr. Mohammed Sadiq Yusuf. He will be talking to us for the next 15 minutes. Mr. Sadiq?
Hello, are you hearing me?
Yes, we can.
Okay. Good afternoon, distinguished participants.
Good afternoon,
I feel highly
sir.
honored at least to take the floor and to give a talk.
Sir, your background is a little bit noisy. Hello? Hello, sir.
Are you hearing me clearly now?
No, you have echoes in your background.
Are you hearing me clearly?
Your background is echoing, sir.
Is it clearer now?
Perhaps you have another device connected to the same meeting. No, sir. You still have echoes in your background. Perhaps you have another device connected to the same meeting. If you could stay away from such other devices, sir.
Can you hear me now?
Better. Thank you so much, sir.
Okay. So sorry, please.
It's okay.
Just like I was saying, I said I feel highly honored and privileged to give a pet talk, particularly to the Unity Bar, Abuja. Essentially, my topic is to speak on the rules and benefits of trademarks. And without wasting much time, well, as we're all aware, discussions concerning trademarks flows from particularly the Trademarks Act Cap 436, Laws of the Federation of Nigeria 1990. And generally speaking, any person, individual or entity who is using or intends to use a trademark can apply for registration. It should be noted, however, that while it is not compulsory to register a trademark, it is, however, highly recommended and advisable to do so, as only by registration can one legally protect and enforce a right of preventing others from unauthorized use of the mark. And by way of some select points to note, as concerns the rules governing the registration of trademark, generic terms must not be considered as trademarks. For example, the word chair. Again, another point to note is deceptive trademarks, particularly those that are likely to deceive or mislead the consumers. For instance, marketing margarine under a trademark featuring a cow, for which consumers here will likely associate the mark with dairy products. Or for instance, pure wood for 100% meant for 100% synthetic material. Another point to note is marks considered to be contrary to public order, morality, or scandalous. Designs, flags, amoral bearings, official hallmarks, emblems of states, national and international organizations. Another point to note here on the rules is marks that are in conflict with prior existing trademark rights. That is, marks that are identical or similar to existing trademarks, which is likely to cause confusion. Another point to note is marks that is more or less an imitation of an existing trademark. For instance, the brands Sony, as in S-O-N-N-Y, and Sony, as in S-U-N-N-Y. Generally, these are areas that, as much as possible, must not be allowed to go for registration as trademarks. Some of the fine points to note for marks that are considered good to proceed to registration are things like invented and creative marks. In other words, marks that are inherently distinctive, hence capable of being distinguished. That is easy to memorize, write, pronounce, and fits the product or image of the business. Again, coined or fanciful names, for instance, Dancer, Kodak. Generally, again, to file or apply for it for the registration of marks entails the applicant identifying the relevant and particular class. This is especially so to avoid any query that such sister organizations like NAFDAC.
Yeah.
Are you hearing me?
Yes, sir.
Okay. Sister
There's a
organizations
noise
like
in your
NAFDAC.
background.
Are you hearing me clear now?
Yes, sir.
Good. Sister organizations like NAFDAC may likely point out, you know, for most of these products that has to do with further registration with NAFDAC, it is essential that any applicant for a mark must not only get that mark registered, but get it registered in the relevant and particular class. And so it is not surprised that when you're not properly guided and you file a mark for a registration, incidentally, by the time you approach NAFDAC, chances are the NAFDAC will turn you back and say, no, yes, we can see evidence of you trying to register this mark, but this is not the proper class you're supposed to register. And the reason is because the classification, which is the NIST classification that the registry uses, NAFDAC also have knowledge of what are contained in those classes. So this, in a nutshell, are very important rules that must be taken into consideration when applicants are filing marks for registration and protection. I want to take us through briefly what are those benefits that trademark registration confers. These benefits includes, one, it enables consumers to identify or distinguish a product or service of one company or proprietor from those of others. And the second point here is it plays a pivotal role in the definition of the image or reputation of enterprises and their products or services in the eyes of the consumers, hence creates trust and loyal clientele, goodwill, as consumers valued trademark brands. Another benefit is it provides incentives for reinvestment and improving quality standards of products and services. Another benefit here is it ensures licensing or franchising opportunities. Another point is, again, it is an important marketing tool which confers exclusive right to the use of the registered mark and prevent others from using it on similar goods or services. Again, the registration of trademark is a useful tool for obtaining bank loans and finance. As a mark right owner can easily pledge or sell the trademark for cash. And the last point I want to mention here is registration of trademark is a very valuable business asset. For instance, famous marks like Coca-Cola, IBM are reported to have assets to the tune of almost above 80 million US dollars. So generally, we can appreciate the benefits of what trademark registrations are. But the salient point to note is this. Unfortunately, people make mistake that because, for instance, you file an application for registration of a trademark, and probably maybe you've been issued with an acceptance letter. We assume one has registered a mark. Unfortunately, this is not the picture here. Issuance, you being issued is an acceptance letter only confers a provisional approval for your application for registration of a trademark. So in other words, before you can say you have a registered trademark, it is a situation whereby that mark, that your application must have certificate. But that does not mean that mere obtaining an acceptance letter means you cannot proceed with your business. No, it will allow you to sell, it will allow you to import and the likes. But the only snag there is that, legally speaking, just leaving it at that level, it will be difficult for you to proceed against somebody, a fellow competitor that is trading in that same name that you're applying for registration. And the reason simple is because at that stage, you don't have registration yet. And that is why in trademark, there are stages. Because after the issuance of the certificate, just like the next speaker is going to take us through, whatever you're applying must be published in a trademark journal. And these are journals that the registry issues periodically. And it is the duty of the applicant or their agents to always ensure that at least they have knowledge of that publication, such that at the expiration of the stated period or stated window within which objections are supposed to be filed, it is their duty to confirm from the registry whether or not there has been any objection raised. Of course, if there are, definitely the address they gave us at the time they are registering the mark, the registry will gladly get across to them with the fact that, yes, so-so person is objecting to the registration of that particular mark. Of course, the grounds and everything will be stated therein. So in a nutshell, this is what I feel we should avert our minds to when we want to register trademark, and also essentially know the importance of the registration. The importance of the registration is not just for you, for instance, to just get through the hurdle of NAFTA, but it is particularly to the client's advantage. Thank you very much.
Thank you so much. Thank you so
Madam
much.
Tachi,
Yes, sir.
please permit me to just run down from the points that Malam Sadiq Yusuf has raised. That it is very important that there should be due diligence, and due diligence is required in trademarks registration. He has raised very important issues, and in particular, I want to raise those issues in connection with the provisions of the Trademarks Act. Section 4 of the Trademarks Act expressly requires that application for trademarks must be in respect of particular goods. And particular goods relates to classification of goods. And the classification of goods that this country adopts for now is the NINT International Classification of the NIST Agreement on Registration of Trademarks and Service Marks. It is very important to take note of. Number 2, Section 9 of the Trademarks Act provides for this appropriate section. Section 11, in Section 11, the Trademarks Act speaks about deceptive marks and marks that are not registrable. So lawyers are expected to advise their clients about what is registrable and what is not. Section 13 of the Trademarks Act talks about identity or resembling trademarks. Mark lawyers to understand that registration may be refused by the Trademarks Registry. And very importantly, also Section 18 talks about the that there must be an application for trademarks before the registrar. So any person who is
Mr. Registrar?
The owner of a trademark must be the person that would, or if he is authorized or legitimately have authority or permission or license to register such trademarks. In Section 19, the Trademarks Act talks about publication of marks as accepted, meaning that all marks that have been accepted by the Trademarks Registry will be caused to be published in the Trademarks Journal. The purpose of publication is to allow any interested party to oppose the mark. This is as required by Section 20. Marks are published as required by Section 19, and opposition is permitted, allowed by Section 20. Now, the duration of registration is 7 years at the first instance, but then is subject to renewal after each 14 years. This is the cycle of trademarks registration. I just feel that I should throw more light on all the silent issues that Mohammed Sadiq Yusuf has eloquently presented to you. Thank you very much.
Thank you, Mr. Registrar.
Okay.
Well,